She filed a police report and a protection order. She said, Mom, once he finds out what I did, he's going to kill me, Mom. And then he did.
A young pregnant woman told her mom that her abusive ex-boyfriend would kill her for going to police. And he did. Now that man has been sentenced to decades in prison for murdering the 19-year-old and their unborn child. There's so many layers to this case, like a long history of violence, guilty pleas, and an active arrest warrant that's never been served. We're breaking down everything we know. Welcome to Sidebar, presented by Law&Crime. I'm Elizabeth Millner, in for Jesse Weber. This heartbreaking case has finally reached its conclusion. 24-year-old Devon Blair has a well-documented history of abuse, and now he'll be serving the next few decades in prison for the brutal murder of his ex-girlfriend, 19-year-old Brooke Devinney, who was pregnant with their unborn son when she died. Despite pleading guilty to a prior assault in December of 2023, where he dragged Brooke naked by her hair at knife point, Devon Blair remained free on bond. What's even more shocking is he had an active warrant for violating the terms of his release just days before Brooke's murder. So how did we get here? Well, last summer, a text came into 911 after a person heard screams coming from Brooke's home in Columbus, Ohio. This is what the official arrest report says. On June 16, 2024, at 7:28 a.m., Columbus police officers were dispatched to the 4600 block of Parkwick Drive on a domestic violence incident. Upon arrival, the officers located a victim, identified as Brooke Devinney, age 19, injured and unresponsive. Franklin Township fire medics arrived and transported Devinney to a local hospital in critical condition from blunt force trauma injuries. Devinney was pronounced deceased at 8:45 a.m. Devinney was pregnant at the time of her death. According to the Columbus Dispatch, Brooke was 14 weeks pregnant, and she was planning to have a boy that she reportedly was going to name Aiden. The report goes on to describe the suspect's attempt to flee the scene. It reads, quote, "The first arriving units observed a suspect fleeing the location, but were unable to make an apprehension. After an hours-long search, the suspect, identified as Devon Blair, age 23, was taken into custody. Blair had active arrest warrants at the time of this incident. Now, according to the report, Devon was on the run when officers responded to that 911 text. We'll dive into his violent past in just a bit, but first, watch how this chase unfolded. As police arrive, you can hear officers discussing Devon's outstanding warrants.
He's got a felony warrant. It's essentially part of what we're doing is working a 50A.
Okay. Yeah.
So I would treat it the same way. 4623.
Yeah, 46.
There he is. He's running. Hands up! You're under arrest!
Now, while some of the officers chased down Devon, others discovered that horrific scene inside Brooke's home.
I think he's back at the house. Got some screaming inside.
You fucking killed my sister!
Where's your sister? Is he inside? Is he inside?
No, he dipped. I don't.
Where's your sister?
She's upstairs in her room. Upstairs to the left is the door. She killed her.
The search for Devon Blair ended up leading officers to a vacant church where he was finally cornered.
Columbus police, if you're in here, sound off!
We'll just have to go slow. I'll hold this hallway, or if you want to hold the hallway, I'll kick stuff around over here.
Columbus police!
Okay.
Columbus police, if you're in here, sound off!
194. We haven't made it very far in here. Is there any canines close?
Any canine channel 3, canine channel 3.
It's just a garage.
Yeah. Cobwebs all over the damn place.
I haven't ran into one this way yet, so. Must not be canine.
Get down! Get on the ground! Hands behind your back!
Hey, by the way, there's a reason Sidebar is the 16th most popular show on YouTube right now, and no big deal, but Joe Rogan, we're coming for you. Just like there's a reason Morgan & Morgan is America's largest injury law firm. They're a firm with more than 1,000 attorneys, and that's because they win a lot. They've recovered over $25 billion for more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million, 40 times the insurer's offer of $650,000, and another client in Pennsylvania received $29 million after only being offered $500,000. Now, if you think your case isn't even worth millions, why not start a claim and fight for what you deserve? Morgan & Morgan makes it truly so easy that you can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on your screen. But Devon didn't go quietly. He even threatened the officers trying to cuff him.
Stop. Let me get my order. Hey, we'll deal with that later. Okay? 191, she's gonna get a wagon over here. Keeps trying to hit his head.
Bro, I'm cool. Let me go, bro.
No. You're the one that did it.
Let me go, bro. Let me go, bro.
I think it's like Cottrell. It's right on the corner.
They found it.
Bro, let me go, bro.
No. You want to slam your head and be stupid?
That's what happens.
We'll just help you make it good.
Okay, thank you.
Racist?
They don't even do this.
Yeah? I'm racist.
Let's see what this is being
For
like.
sure, right.
Where my legs go?
No. You want to do stupid stuff? You get a hobble and we'll put him on the side. Sarge, you get a hobble and we'll put him on the side. Got one.
Damn, I'm tripping. I get on my side, my damn self.
Ain't no one listening to you right now, guy.
Now, faced with the choice, cooperate or be strapped into a stretcher, well, let's just say he didn't choose the former.
This can go two ways. You can go on a stretcher and we can strap you down, or you can be a man and sit back here. It's your choice. Which one's it going to be?
Man, I didn't even want to be on these niggas clean.
You want to be a man, or you need to go on a stretcher?
Are you gonna act like a child or are you gonna do everything up? It's a yes or no question. Man, it's in there enough. It's paid, or we're gonna have to stretch. Yes or no? Yes or no? Stretch her out.
Say he's standing or no?
No, he won't make a decision.
He's
So.
talking to me crazy.
Let me answer the question.
Yes.
Let me answer it for you. So we're gonna put you on a stretcher. You don't
Stand him up.
I said, yeah.
Ready? On your feet.
Use your feet.
Start
Y'all
walking.
gonna put me on a stretcher? Y'all gonna work?
Start walking.
Jesus. Stand up.
stand up.
Y'all gonna work for it. I don't want to be on a stretcher. I want to make it easy for y'all. But
Oh, so we're gonna work for. We'll strap you to the stretcher then. I don't give a.
what's your name?
Say it. It's 2893.
What's your
Wednesday,
address?
Thursday, Friday. 120 Marconi Boulevard.
All the way left. Yeah, I should have busted my head on your thumb. I caught your butt.
One more side. One more side.
Side.
Guys. Rolling towards you.
Let me like this. Y'all sleeping.
Okay, we got this side. Yeah.
Work together with this. Ooh.
Wheels on that side.
Get on the head.
2 and 2. Ready? 2 and 2. Keep on that side.
Don't worry about him. Don't be, grab those caught. There you go.
Yeah. Let them go first and we'll follow.
Hey, you got CP on my face.
Yep. I got you. Wheels down, it rolls. Kick that air on.
Yes. Good.
I can ride.
All right, get in there. Yeah, but with the cruise truck.
Weston.
Devon was later booked into the Franklin County Jail. Now, as it would turn out, this wasn't the only time Devon had gotten violent with Brooke. Like we mentioned, he had a well-documented history of violence against her. That violent history included choking, beatings, threats to kill her, and even holding a knife to her throat. And despite all of that, he remained free until she was murdered. Now, according to reports reviewed by the Columbus Dispatch, one of the most serious earlier attacks happened in December of 2023. On December 28th, Devon smashed the windshield of Brooke's car. He forced her to strip naked before dragging her by the hair and holding a knife to her throat, saying, "I'll kill you." When officers caught up with him, Blair punched and bit one of the officers in the head during the arrest. Devon was charged with felonious assault, strangulation, assault on a police officer, and felony domestic violence, and he pleaded guilty to 2 of those charges on May 16th of 2024. But somehow, even after pleading guilty, he was actually allowed to walk free. The Columbus Dispatch reports that Judge Michael Holbrook released Devon on a $10,000 recognizance bond, meaning he didn't have to pay anything up front to remain out of jail ahead of sentencing. Judge Holbrook ordered him to wear an electronic ankle monitor and stay away from Brooke. The judge even expressed hope at the time that Devon would comply with his release terms, saying, quote, "I'm taking a chance. Don't disappoint me." That chance didn't last long. Just days later, on May 31st, Devon's bond was revoked for violating his release conditions and failing to participate in a pre-sentencing investigation. A warrant was filed that same day in response to the violation, but it would never be served. Devon attacked Brooke 2 more times. On June 12th, just 4 days before her murder, Brooke told police that Devon attacked her during an argument in her car. She said he punched her in the face and warned her not to take the freeway exit toward her parents' house. When she did anyway, he punched her in the eye and hit her several times in the head. He then picked up a can of car cleaner and threatened to bash her head in. Now, 4 days later, police would receive that 911 text reporting that something terrible happened to Brooke. During Devon's arraignment on June 18th of 2024, he interrupted the court with expletives demanding bond. Let's take a listen to that.
Now shut the up and give me a bond. Say, okay, granted, give me the out of here to my rack. You're
and died as a result of her injuries to her fetus also.
Alright, smack this when I get out of here.
Please be quiet.
Shut the up. Should never brought me down here. I ain't wanna come. You forced me down here and I give a shut up.
Counsel, on behalf of your client.
They went to the next of kin of the family, no further accidents and no weapons existed involved the same prosecution.
Now, Judge Jim O'Grady initially set bond at $11 million, but it was later revoked, and Devon Blair was ordered to remain in jail until trial. Now, the case came to a head on June 21st of 2025, when he entered a guilty plea to 2 counts of involuntary manslaughter, 2 counts of felonious assault, and 1 count of strangulation. He was sentenced to 46 to 51.5 years in prison, plus another 2 years for the prior assault. As a part of his plea deal, according to the Columbus Dispatch, Blair agreed to make no applications for early release. At the sentencing hearing, Brooke's mother, Brooke Devinney, addressed the court in an emotional victim impact statement. She read from a series of text messages her daughter had sent to her in the last weeks leading up to her murder, like words of "I love you" and plans to get milkshakes, but others that described the physical abuse she endured, a previous miscarriage, and her growing fear that Devon would kill her if she reported him to police. According to the Columbus Dispatch, Billy told the court, quote, "She only wanted him to love her in the way that she loved him. He took her life. He made a choice to take her life. He could have walked away, but he didn't. He chose to kill her." Billy recounted a moment when her daughter had tried to protect herself, filing a police report and requesting a protective order, but feared it wouldn't be enough. Let's take a listen.
She filed a police report and a protection order. She said, "Mom, once he finds out what I did, he's going to kill me, Mom." And then he did. He selfishly took her and my grandson away from me.
Billy also condemned the legal system despite repeated warnings that allowed Devon to remain free, saying the system failed her. No matter how many years he spends in prison, it will never be enough. It won't bring her back. When given the opportunity to speak, Devon cried as he addressed the courtroom, referring to Brooke as, quote, my best friend and the love of my life. He went on to say, I think about that night every day and every night. I wish I could go back in time and just walk away. But for the Devinney family, no apology could erase the pain of what was lost or the many missed opportunities to prevent it. So I have a great guest with me to break this all down, and that's criminal defense attorney Joe Tamburino. Joe, always great to see you, and thanks so much for joining me today. I got to ask you, how common is it for someone with a very violent history and a guilty plea at that to be released on their own recognizance bond or released on a recognizance bond while awaiting sentencing? How rare do you see that, or how often do you see that?
Well, thanks for having me on, Elizabeth. It is rare. Usually when you have someone with such an extensive history of domestic violence and they plead guilty to a domestic violence felony where they used a weapon, because remember, in the December 2023 case, he supposedly and pled guilty to a domestic violence case where it was alleged that he used a knife. That's a dangerous weapon. And you have that and you plead guilty, usually they're taken into custody. But again, that's up to the judge. Some judges will, some won't.
And in your view, kind of what went wrong to allow Devon Blair to remain free despite having an active warrant out against him?
Well, what went wrong is that we have to make sure in the system that all judges are educated on domestic violence. And, that's going to depend upon how do you become a judge in one jurisdiction or another. Like here in Minnesota, judges are first appointed by the governor, and then after that, they run for re-election. In many states, there's simply just an election for it. But very few states, if any, have qualifications as to what you need to do in your career before you're even eligible to become a judge. And then obviously, once you become a judge, what are the standards or what are the educational requirements that you would have to go through as you proceed in your judicial career? So I think a lot of this would be alleviated if we had judges who understood the nature of domestic violence, especially when we're dealing with defendants with an extensive history, and when the person allegedly or admits to using a dangerous weapon. In those cases, the court has to seriously consider putting them in custody after they've pled guilty to their sentencing.
I'm curious to know, Joe, one of the judges in this case said that he was going to take a chance on Devon Blair. And by taking a chance, we all kind of know what the outcome ended up being. But in your opinion, do you think that, with some judges, I can understand both ways of why judges feel like they should take chances on defendants. They believe that there's possibly some good left in them. But in this case, it seemed like kind of the bad outweighed the good for sure. But in terms of just Judge Holbrook saying that he was going to take a chance on Devon Blair and then this happened, what are your thoughts on just the judge's discretion there?
Well, the judge does have discretion, and I'm sure it's something that the judge never wanted to happen. I mean, of course, we're all human beings. We never want, when we take a chance on someone, for them to do something like murder another person. Absolutely not. However, there are good chances and bad chances. Here are good chances. Good chances are when a defendant comes to the court and shows that he's done extensive treatment. Maybe he's gone through an inpatient alcohol program or intensive outpatient alcohol program. Maybe he's gone through a 3-month course on anger control. Maybe he's gone through a 2-month course on domestic abuse issues. If a defendant comes to the court doing all of that, showing that he's gotten to the roots of why he's an angry person, of why he attacks women, and he really has successfully completed those programs, yes, that's a good chance. As opposed to a situation where, you just have a defendant who says, look, I'm going to do better. I'm doing better now. I've been great since I've been out on bond. But has there been any programming? Has he successfully completed anything? So, you have to weigh the chances. When a defendant has completed all that types of programming, that's a good chance. When they haven't, you got to question it.
And this case is especially heartbreaking given that the victim was pregnant with the defendant's child. And then you have this other aspect of, her wanting to report this information to law enforcement. She did everything right. She told her closest family. She told law enforcement about what was going on with her. And then obviously this happens. And I think always a question when we see these very big domestic violence cases that were to happen that end up like this, where a victim ends up being murdered. I think a lot of people go back to, okay, well, why did she stay with him? Why did she continue being with him? And then we kind of know from her mom a little bit from the reports out there that were saying that her mom just, was saying that her daughter just wanted his love to pretty much just go back to how it was. But in terms of why defense attorneys may get that question of why didn't the victim leave? Why did she continue to stay? Why would she have a child with him? What kind of answers do you have to that? Because I feel like it's a double-edged sword where you say, okay, leave and then something bad were to happen, or stay and something bad were to happen. It really just feels like there's no good outcome out of these horrible, horrible cases.
Well, you just hit it on the head with no good outcome, because in many situations you will have victims who simply want the perpetrator back in their lives, regardless of the fact that they have abused them, regardless of the fact that they are dangerous people, violent people, they still want them back in their lives. And that's something that, we're never going to cure. We just can't cure that, because as adults, we can all make decisions. As long as we're not under some mental defect or under the influence of a mind-altering substance, we are allowed as human beings and citizens in this society to say, look, I'm making my own decision. I want him back in my life. However, there are some guardrails. Like in this case, we had the victim who was calling the police, saying that there was, no contact orders basically being broken. In that kind of a situation, a warrant should have went out. Not only that, it should have been executed. And then once the defendant was arrested on violating his conditions of release, he could have been held. His prior bond could have been revoked. So there are some guardrails to the system.
And what else could have been done in this type of case that could have possibly have prevented this from even happening?
Well, the only thing that could have prevented it if he remained in custody. I mean, obviously that's clear. But other things that could help is when you have a defendant who has a pretty violent history, and the last time he abused this victim, he did something very degrading, pulled her around in public by her hair, made her strip naked in public. That's very degrading conduct. That should send off red light signals everywhere to a judge. So what you could also do as part of a condition of release is put a GPS monitor on them. Where you have a monitor that you can see if this defendant is even getting close to the victim's home or the victim's place of business or the victim's school. Now, of course, you will have defendants who cut off the monitor. Okay, if that happens, immediate warrant and immediate arrest. But you can try to prevent that by having these GPS systems, and they're available everywhere.
And is there any type of legal way to hold possibly the court accountable when a released offender goes on to commit a very violent act such as a murder like this?
No, we have what's called discretion in our system. For example, a prosecutor doesn't have to charge every case. We elect our prosecutors, and then they hire prosecutors who go to court every day. They're the assistants. And we give them, and rightfully so, the discretion to charge cases and not to charge cases. Why do we do that? Because not every case should be charged. People sometimes make accusation of crimes against other people that sometimes are not true at all, or even if there is some basis in truth, it doesn't rise to the level of probable cause, or certainly not something that you could prove beyond a reasonable doubt. So discretion is built into our system. And because of that, almost all public officials, like we have prosecutors, judges, are going to have immunity for their discretionary judgment calls. So, and that is good to have in the system, except obviously in some cases, the calls aren't made correctly.
And what's your thoughts on Devon Blair's sentence? I mean, he was given a plea deal, or he pleaded guilty, and he wasn't given life in prison, given this very heinous and violent act, plus, obviously the murder too. But in terms of your opinion on the sentence, do you think that was just? Do you think that was fair, even though he did plead guilty?
Yes, a 50-year sentence. And I believe what also was part of this is that he couldn't ask for early release. So let's assume that he's going to serve 50 years. I believe he's 24 years old now, so that means he's going to be 74 years old by the time he's eligible for release. I mean, quite frankly, the odds are when you're in prison for 50 years, you're not going to make it to 74 years old. So basically, this is like a life sentence.
And what are your thoughts on just the kind of sentence that he had when he was kind of telling the court pretty much his side of things, where he felt bad pretty much and that he wishes he could go back? I mean, obviously it's too little too late. I mean, his ex-girlfriend is dead and their child is dead too. But in terms of him seeming remorseful during his sentencing, do you buy it?
I don't personally buy that, but it is the right of every defendant. It's a right of allocution, which means that a defendant can tell a judge what their position in the case is, how they feel, how this has affected them, how they have changed, their remorse, their contrition, what they want to say to the victim or the victim's family. So that is all of our right to do that. And though, in many cases it is too little too late, and in this specific case, no, personally, I don't buy it, but it is his right to do that.
All right. Well, Joe Tamburino, I appreciate your time and your insight into this case. Before we sign you off, is there anything else you would like to add about it?
No, and thank you for having me on.
Always. Thank you so much, Joe Tamburino, criminal defense attorney. We appreciate having you on Sidebar today.
Thank you.
Well, that does it for this episode. Be sure to subscribe to us anywhere you listen to your podcasts, whether it's YouTube, Apple Podcasts, or Spotify. I'm Elizabeth Millner in for Jesse Weber, and this has been Sidebar presented by Law&Crime. Thanks for watching, everyone.